All right, looks like we are live. If I could ask my moderators to just double check that, cross check each platform, just make sure that we are good, since I won't be able to continuously monitor it. And we're almost ready to go here. Sound check. Give me a thumbs up if everything sounds good. Amazing. Welcome, everyone. Welcome everyone who's here in the Zoom meeting, and of course, welcome everybody who's watching on social media. We're actually broadcasting this workshop live. This is the first time we've ever done that, and we're broadcasting on YouTube, Rumble, Facebook, and LinkedIn. So we're really getting the word out today. And so I think most of you guys know me. I'm David Greenberg. I'm the founder and managing director of the Freedom Studio. Just to make sure you're in the right place. It's my pleasure to have you here today. Before I hand over the workshop to our presenter, Julian, I just want to say a few words. Just share some thoughts real quick to help you guys get the most out of today's workshop. And I'm reminded of that famous saying, fish for a man, feed him for a day, teach a man how to fish, feed him for a lifetime. As an education organization, I'm all about teaching you how to fish. I'm all about helping empower you with the right knowledge that's going to allow you to create the life that you're looking to create and be of value and show up in the world the way you desire, right? Based on your specific mission and purpose. And all of us have different reasons and different missions. Everyone's unique. I'm just here to help facilitate that for you. And that's why we focus so much on education. There's another famous saying, when the student is ready, the teaching will appear. So perhaps that's true for you today. Maybe you're showing up today because you're ready for the next level. You're ready to learn something that perhaps you haven't learned before, something new, just a different way of looking at things. So to get the most out of it, I want to invite you to be highly teachable. What does it mean to be highly teachable? You're neither extremely naive and just accepting everything, but you're also not rigidly skeptical. It's kind of like being in the middle. You're just taking everything in, you're just taking it under advisement, you're listening carefully, you're taking good notes, you're contemplating everything, running it through the usual filters, your intuition, your reason, and just see if it resonates. If it does, great. If it doesn't, that's okay too. We focus on things that are practical. That's another reason I'm doing this workshop is we want to give you practical tools, not just philosophy or theory. Nothing wrong with philosophizing, nothing wrong with contemplating things, but my goal is really to give you things that you're going to actually be able to use in your life, right? Something that's going to be of practical value. I can also attest to the value of what we're going to learn today based on both firsthand and secondhand experience. And there may be other people in the room who can do that as well. Of course, you're going to hear a lot of great testimonials and success stories. So just take that all under advisement. And remember, the information you're going to learn today is broadly applicable. Most people come to us because they are looking for commercial remedy, but you're going to be surprised to see how you can use this knowledge in many different aspects of your life, not just in the commercial realm. Jim Rohn famously said, all good will be attacked, all value must be defended. So do we not have a duty to defend the value that we're creating and maintaining? I would think that we would. And this goes back, of course, to the principle of self-defense as well. We don't want people to walk over us or our rights, and we want to basically shield and protect the things that we're creating that we know are of value. For all the reasons that I've mentioned and more, this is why we've decided to partner with Standing on the Rock. We partner with very few organizations, as you guys know. But Standing on the Rock, Julian and Maggie, we've decided to partner with them because they've created something that, frankly, it doesn't make sense for us to try to just go and duplicate that. It's better to learn from those who've already forged the path. So I want to get you guys to give a warm welcome to Julian, who's going to be the presenter today. And he's obviously going to take you through the bulk of the workshop. I'll be here in the background, and my team will be here to assist. I may jump in and interact and help, answer some questions and share from my own experience. But it's going to mostly be Julian presenting. So I want to invite you to give him your attention. Also, keep in mind this is an introductory workshop. And like all introductory workshops, you're not going to learn everything in one day, but you are going to get exposed probably to a much deeper level of knowledge that you would otherwise. So there's going to be an offer for you to continue that study and go deeper. So just keep that in mind. This is an introduction. So having said that, it's a good time to think about it. Is this for you? Are you ready for this? You can decide. You have free will. So I invite you to sit back and engage. And of course, you'll be on mute most of the time, but after the presentation is done, there'll be a chance for everybody to interact and for you guys to ask questions and get your questions answered. So, having said that, I think that's enough of an introduction. I don't want to try to steal the show here. So I'm going to hand it over to Julian and welcome everyone again.
Well, thank you so much, David, for that wonderful introduction, and very much appreciate your kind words. Thank you for this opportunity and the ability to speak to your listeners today. I'm going to go ahead and present the first of our two-part workshop today. We're going to get into the powerful remedy of equity and what it can do for you. But first, we always like to open up with a prayer. So, Almighty Lord, Father God, we just come before you today in total thanksgiving for this incredible remedy that you have preserved over the last 700 years. Lord, like a voice crying out in the wilderness, we speak your words of truth, and we hope that others will come to listen. In these end times, Lord, we thank you for raising us up as your last days army to discharge freedom and hope across the land, and to redraw old battle lines that were previously drawn along despair and frustration and persecution. We redraw those along the lines of hope and freedom. And Lord, we know that your people are destroyed for lack of knowledge. So we seek first the knowledge and the wisdom that you have buried beneath the earth and hidden from those who would try to censor it. We thank you that you guided our hands in order to dig it up. And I just ask that you speak through us today in order to help impart that wisdom to your children, that they may walk in freedom and just be able to spend more time with their families and enjoying their lives, because they begin to discharge their cases and break off the yoke of financial instability and burdens off of their backs. Thank you so much for all of this, Lord. We bless it to your holy name. In Jesus' name, amen. All right. So our first class that we developed is called Honor with Equity. Obviously, we're standing on the rock. My name is Julian Swan, and my wife Margaret and I run this ministry. We began teaching nearly 3 years ago, and the Honor with Equity class was our first class. It was something that we learned from several different mentors. We sought out the very best of the best and learned everything that we could. And then we did a lot more research and kind of shored up some things that might have been missing, and developed just a comprehensive class that takes you through primary source materials in order to ensure that you're getting the very best education possible, that there's no situation that you can find yourself in where you're left on your back foot. We are 100% successful with every single student that takes this all the way. There's just a couple of caveats. They have to actually commit to taking it all the way, use all the tools that we give them. They have to stick with it. They can't mix it with any other process out there. And as long as they do those two things, there's been 100% success rate, and we've taken on everything from little traffic matters to income tax, business tax, mortgages, criminal cases. Even at the federal level, we have been successful across the board. I don't know of any other remedy out there that can offer a 100% success rate. Most things are very hit or miss. Now, that's going to require you to kind of change your thinking on some things. So anybody that's been in this movement for a long time is very familiar with the arguing and the fighting that goes on. We like to call these other processes patriot processes, because they're very popular in the patriot movement, but you wind up paying a lot of money and you get something that works maybe 10% of the time. And it seems to be just the judge just didn't feel like dealing with it that day or something. And it can often feel like a hamster wheel. I mean, I know a lot of you, some of you may have been in this movement for a couple of years. Some of you may have been in this movement for 15 years. I would just ask if you have the experience of 100% success rate. I guess if you did, you wouldn't be here today. So maybe it's time to start looking at something new. You gotta release what's been wasting your time and take on something that is proven. And we can take you to the primary source material to back up absolutely everything we teach. So I want to get into why some of these other processes aren't bearing the fruit that we would like to see first and foremost before we move into what we teach. There's a lot of processes out there, and there's some fundamental flaws that I would just like to highlight. Now, before I go into this, I don't want to upset anybody that's become perhaps emotionally attached to some of these other processes. I mean, we all stand on the shoulders of giants, and we're very thankful to the people that came before us, everybody in the common law, everybody doing secure party creditor, conditional acceptance. I mean, these things have been around for a long time. The late 80s, early 90s saw an explosion in the redemption process, which became the secured party creditor process. You had Melvin Stamper's famous book, Fruit from a Poisonous Tree, in which he describes the secured party creditor process. You had Roger Elvick and so many others that blazed a path. There was a lot of trial and error along the way, but we thank everyone that came before us because we were able to glean from them what was most effective about what they were doing and build upon what was not as effective. So ideas like getting investment brokers to look up people's social security numbers in court cases and see that these courts are actually trading bonds in every case that comes before them. That the courts actually have a financial interest in every case, and this is true across the Western world. The UK, Canada, Australia, they're all doing the same thing. They're all committed to the same commercial system. The central banking practices that basically force every government institution to have a financial interest in everything they touch. So that was a very important teaching that we learned from people like Roger Elvick and others that brought this forward. Victoria Joy and some other very influential people in the movement. But we've carried the ball a lot further down the field, and we've been able to take what was most effective and build on the rest. So when it comes to common law, for example, I have a couple of maxims here, just talking about why it's so easy for courts to overrule the common law. There's a maxim that states custom supersedes the common law. The custom overrules the common law. Well, a custom is just something that a judge comes up with, and if nobody challenges them on it, then it becomes a local rule, a procedural custom that is unique to that court. And at the federal level, these things tend to spread very fast. At the state level, it's a little bit slower process. But over the last 100 years, there's quite a lot of customs in place that are barring the gates for a lot of common law pleadings and argumentative remedies, motions, and things. There's a lot of people that wonder why courts just flat out reject their common law pleadings. Well, the reason is probably because the court has some kind of custom that's barring the way. So there's plenty of custom maxims that state that custom overrules the common law. There's not a single maxim that states that custom overrules equity. Equity is the highest jurisdiction, as we'll get into in just a bit. Speaking of the secured party creditor process, again, we're very thankful to Melvin Stamper and Roger Elvick and everybody else who paved the way. But the main crux of the secured party creditor process is to claim status as the beneficiary of the all caps estate, right? And the whole culmination of the process is, claiming security interest in that estate and reversing the role, becoming the beneficiary again. I've seen this be effective sometimes, and in more serious cases like criminal matters, I've seen it just get utterly decimated. And I don't want to go too deep on that, but I just wanted to bring forth some maxims that may explain why that's happening. So we have consent makes the law. We have persons who consent and those who perform are subject to the same penalties. So this is just speaking to, if you consent to the contract and you've performed under the contract, especially for a sustained period of time, because you have the third one that says no injury is done by things long acquiesced in. If you have acquiesced to the contract of the birth certificate, the social security number, for long periods of time, and then you suddenly try to claim beneficiary status, well, the entirety of your life up until that point paints a completely different picture. You've been acting like the surety since the day you were born. You may be able to claim, oh, well, there was no meeting of the minds, but when you got older, you started accepting the benefits of those contracts. There wasn't a meeting of the minds when you were a baby, but you got older and you decided to go get a driver's license using the social security number, open a bank account using the social security number, rent a car using the driver's license. I mean, there's 100 ways that they get you to contract. And if you've been acting like the surety your whole life, then it's not going to go over very well with a court when you suddenly try to claim beneficiary status. I think sometimes it just due to the sheer complexity of that process, maybe courts will just throw out the case. But for more serious stuff like mortgages, criminal cases, really serious tax bills like over $100,000 or $1 million, it's going to be a much different story. And we've had successes in all of those areas because our process is fundamentally more simple, really, and doesn't involve this contradictory scope of a person's path where they're acting like the surety their whole lives, and then all of a sudden they try to claim beneficiary when they get a problem with the court. We actually remain as the surety in equity, and we teach that we have an incredible amount of power in that role. So there's really no need to even claim beneficiary status in the first place. You are a voluntary surety. You were made so by your birth certificate, social security number, and the amount of power that you have in that role is unbelievable. And we're going to get into what all that means. A big one that I see out there, and this is really encompasses like 90% of the processes that I see. And I mean, a dozen cases cross my desk every single week, and most of them have prior history of, well, we tried this process, we tried this process. So I've seen it all. Most processes out there involve arguing and teaching the law. And when I look at the filings that people are submitting to the IRS, to the CRA, to courts, there's almost always some arguing going on. There's laws being cited. There's quotes from Supreme Court judges. There's all sorts of things that people are bringing out in these filings, and they're thinking like, well, surely if I point out my constitutional rights or my charter rights or whatever the case may be, surely the judge will be compelled to listen to me. There's a big issue with that, and we'll get into what it means to create controversy in a little bit, and why that's actually going to do more harm than good. But here's a really nice maxim I like to cite in these cases. In clear cases, he errs who cites legal authorities because obvious truths are manifest and do not have to be proved. So that forms the basis for a lot of our process. I mean, we don't argue with them at all. We don't argue facts, law, jurisdiction, or venue with them. We don't challenge them on any of that stuff. It's already obvious what the law is. They already know what the law is. And as long as you don't contract with them by arguing and fighting them and challenging them, then they'll be required to follow the law and discharge your case. It's just that you cannot leave them an open door in other areas by filing things and fighting with them and creating controversy. I might as well cover that now. Why is creating controversy bad? The court system was set up to eliminate controversy. So, one person claims one thing, another person claims another. The government wants to throw somebody in jail. They don't want to be thrown in jail. So you have to have a third party mediator to come in and settle the matter. And that's where the judge and the court come in. Basically, when two people can't agree, but they demand that there be resolution, that is the role of the courts to come in and provide that resolution. So controversy is anytime you argue something that is different to what the other side is saying, you make a claim that the other side doesn't want put upon them, or they're making a claim against you and you're arguing why it shouldn't be put on you. All these things create controversy. So when you go into the one venue in all the world that was created to eliminate controversy, and then you just make a bunch of controversy by arguing and trying to teach them the law and citing laws, all you've done is place jurisdiction into the hands of the court. And so you can issue all the bills of exchange and negotiable instruments and promissory notes you want, and they can use those to get paid, and they could use those to discharge the case, but you've left all these other avenues available to them by contracting with them and creating controversy and basically putting yourself under what's called a general appearance, where all the aspects of the case apply to you because you volunteered for that to be the case, because you've created controversy and given the court jurisdiction. They don't have to settle the case with your negotiable instrument. Instead, they can make you pay another way by saddling you with debts, or God forbid, in a criminal case, making you pay by performance in sitting out the time in jail and running up bonds while you're sitting there for them to make money off of, penal bonds and the like. So that's why we don't do that. We don't create controversy. We don't fight and argue. And we'll touch more on how we actually win cases if we can't argue. And then I also just wanted to touch on conditional acceptance real quick. The UCC actually demands unconditional acceptance in all accounting matters. So I have UCC 3-410 here, but of course, if you're in Canada, we have the Bills of Exchange Act, Section 82.1. In Australia, we have the Australian Bills of Exchange Act, Section 49.1. Those are the equivalents. So anything that you see in the UCC, for the most part, is reflected across Canada, Australia, the United Kingdom, New Zealand, South Africa, and all over the Western world. But basically, in an accounting matter, which is what everything is, because as I mentioned earlier, the courts have a financial interest in every single case that they're touching. It says, if the terms of a drawee's acceptance vary from the terms of the draft, you're the drawee, by the way. The court's the drawer, you're the drawee, or the tax agency, or the government, or whatever. They're the drawer, you're the drawee. If your acceptance terms vary from the terms of the draft or the thing that they're presenting you with, then the holder, which is the person that you're returning everything to, the person that you're sending your filings to, the government or the court or whatever, they may refuse the acceptance and treat the draft as dishonored and call you a dishonorable person. In that case, the drawee may cancel the acceptance. That's just saying you can try to come back out of it and do it a better way. So it's saying that there cannot be any variance in what you are accepting and returning back to them. So conditional acceptance is saying, essentially, well, I'll accept this, but you need to change this, and they're actually able to claim that is dishonorable. In commercial matters, there is only honor and dishonor, and if you're in dishonor, then you're basically going to be there under a general appearance, like I mentioned, where all the aspects of the case will apply to you. When you're in honor, then you put the onus back upon them to settle and close the matter. And we walk you through everything in the UCC and the Bills of Exchange Acts in our courses, which can describe that entire process to you. You must be in honor when you're in honor, you actually flip the tables on them and you become the true secured party. Not a secured party creditor, but just the true secured party, and flip the tables on them and require them to follow their own law and dismiss the matter. All right, next slide. So you are going to eat the fruit of whatever you speak and whatever you do. And the words that we choose open the gates to the experiences that we endure through the spiritual and the physical realm. So if you want to open the door that leads to being left the heck alone, then you must speak and do the things that result in being left alone. If you want to argue and fight, then you're going to experience a battlefield every day. So of course you have the book of Proverbs, very famous proverb, death and life are in the power of the tongue, and they that love it shall eat the fruit thereof. Book of Matthew confirms this, for by thy words thou shalt be justified, and by thy words thou shalt be condemned. So this is why we don't argue. This is why we don't fight. There's a very critical verse that talks about agreeing with thine adversary quickly. We'll talk about that in a minute. But when you come into agreement and you just say, okay, well, we recognize that there's an accounting problem here. You guys have a balance that needs to be paid. You guys have turned this into a commercial matter by running up bonds in every case. So let's just handle it like an accounting matter. And we agree with you. Whatever you say we owe, we will pay it. And we simply pay it with a very particular kind of negotiable instrument instead of our hard-earned dollars. And because we leave no other avenues open to them to persecute us by, contracting with them, then their only choice left is to follow their own commercial laws and discharge the matter. So very, very important not to argue and to speak only the things that are going to lead to your success. And that's why we only ask questions in equity. We don't fight and argue with them. So common law is very strict, very rigid, and equity actually came about as a response to the rigidity of common law. So in the 13th century, there was just people were generally fed up with the fact that they could bring a proper cause of action, but then there would be no remedy in the common law available to them that would suit what they needed, or maybe there was a remedy available to them, but the cause of action wasn't something that common law supported. Maybe somebody needed specific performance from somebody instead of just getting paid out a sum of money. There's a hundred examples I could give, but equity was direly needed because courts needed to be able to go outside the realm of the strict law in order to provide the most moral solution to a problem. And if you look up the definition of equity in Black's, it says equity seeks a more moral outcome than that which is available in the strict common law. Obviously, the whole purpose of the law is to provide the most moral outcome. I know that it doesn't usually turn out that way these days, but that is the stated purpose of the law. And so the fact that equity is the greatest attempt to do that, the broadest attempt to really bring in morality and justice into the application of the law, that makes equity the highest jurisdiction. It also happens to be the easiest to come out of if you don't know how to stay in it. But equity gives judges a very broad discretion in everything that they do. If you read the work of Eustace Mullins, he actually lamented this. He hated equity because it gave judges the ability to basically do whatever they want and call it the most moral outcome. Eustace, of course, was from a time long before this process was ever dreamed up or perfected. So the truth is that when you learn equity and learn how they're using it for their advantage, you can actually come in and use it to your advantage and really force their hand to dismiss your case. You are giving the judge quite a broad power, but as we're going to find out in a minute, the judge is the banker. So of course you want him to have a jurisdiction over the case. He's the only one who can discharge it. Now, equity was merged in Canada and the UK. This happened in the 1880s. Australia was a bit of a different process as they adopted the UK's Judicature Acts as their own. New South Wales actually started merging equity and common law and commercial law before anybody else did. They just always did it that way. In America, this happened in the 1930s, so we were kind of the last holdout. Um, but equity has been merged under the overall commercial court system. So effectively, what that means is you can bring equity in any court in the world. You don't need to be in a chancery court. And there's a lot of processes out there that teach that you have to get into chancery court, that you have to be what they call in camera with the judge, which means in chambers, and have a private conversation with the judge. And it's not true. It's never been necessary for us to achieve victory in any case that we've ever worked on. We've worked with people that were performing, I would call that like a pre-1933 equity process. We've worked with people that were doing these processes where they're using silver bonds and they're trying to get in camera with the judge. And it just never seemed to get them anywhere. I mean, there's a number of cases where we've actually helped people come out of that and unmake those filings and then start bringing the equity that we teach, what I would call maybe post 1933 equity is one way to put it. And they seek victory and the case gets dismissed. Actually, the very first case that I ever took on for somebody outside of our family was a case where somebody was bringing one of these pre-1933 equity processes and you're trying to invoke a hearing in a chancery court using silver bonds, doing the thumbprint on their mailings and a bunch of different things. And we help them come out of that, unmake all those filings that weren't getting them anywhere, and then bring the equity that we teach, and the case was dismissed. Oh, excuse me. All right, moving on. Equity was established in the Constitution, but of course, across the Western world, I mean, it comes out of 13th century England, which has been adopted across the Western world in every country. You can look that up anywhere else, but essentially equity is ubiquitous and there's no need to get yourself into a special court or to get before a special judge. They're all required to operate as a chancellor if you force them to, essentially. Yeah. All right. Equity is entirely based upon God's word. We talked about before how it was designed to be the most moral outcome to a case. The reason for that is that it's based on Scripture. So I'll read a few of these here. Romans 2, verse 12 says, "Do not be conformed to this world, but be transformed by the renewal of your mind, that by testing you may discern what is the will of God, what is good and acceptable and perfect." So the world teaches you to fight and argue. The world teaches, or sometimes the world teaches you to conform and knuckle under. Both of those obviously are the wrong way to go. You can see in the example that Jesus set, he never fought or argued with anybody. He asked very, very powerful questions, and he pointed out some very powerful truths that really just left people stunned and just shamed silence. The wicked men of that generation were just put to shame simply by a question or by just a statement, and had to walk away. And so we do the same thing when we go to court. We ask incredibly powerful questions that are perfectly tailored to prick the judge's conscience, to underline the fundamental injustice of basically every commercial court proceeding out there. We have developed questions that really strike at the heart of the inherent unfairness and brutality of the Admiralty maritime system. So when you come in with a question that pricks the judge's conscience and you leave him no other option but to settle the case as an accounting matter, then that is what we've seen happen every single time. James 1, verses 6 through 8 say, "He that wavers is like a wave of the sea driven with the wind and tossed. For let not that man think that he shall receive anything of the Lord. A double-minded man is unstable in all his ways. This really speaks to just being single-minded in your approach. When I say single-minded, I mean don't mix equity with other processes. The reason for that is that there are going to be fundamental um, doctrines of law about those other processes that interfere with what you're doing in equity. There's going to be fundamental aspects that are just inherently contradictory. Equity, the equity that we bring, we use some commercial processes like acceptance, and we're going to describe that in a little bit more detail. But we wrap it in this vessel of equity, meaning we don't fight and argue. We give the judge the power to dismiss the case, and we're just very single-minded in our approach. When you mix processes, this is when we see people get ordered for psych evals in a court. They're trying to send you a message that what you're doing is double-minded. That's why psych evals are scheduled. Matthew 5:25 says, "Agree with thine adversary quickly, whilst thou art in the way with him." In other words, while you're arguing with him, or while you're on the way to the courtroom. "Lest at any time the adversary deliver thee to the judge, and the judge deliver thee to the officer, and thou be cast into prison." So the courtroom is really set up in a very spiritual manner. I'm going to describe that more in a bit, but the prosecutor is very much in the same role as the devil. He's the accuser of men, the accuser of the brethren, as the Bible puts him. He's in the role to accuse you, and the judge is in the role of God. And when you begin arguing and fighting, then it just creates a situation where you're there under a general appearance, you're creating controversy, and before judgment, the plaintiff is preferred. If you're going to play the plaintiff's game before judgment, then you're going to, that's a maxim of law, by the way, before judgment, the plaintiff is preferred. If you play into his hand and create controversy with him, then it's going to put him in a very favorable position. And this is why federal prosecutors have a 98% win rate, because everybody's just arguing all the time. There's another maxim, which is actually an equity maxim, which states that the defendant is preferred after judgment. So if you don't play the plaintiff's game before judgment, you don't create a bunch of controversy with him. Typically, judgment will be rendered anyway. But after judgment, there's nothing for them to stand on. You just treat it as an accounting matter. Excuse me. You accept and return. There's a few other principles that you need to follow, and the case will be discharged. All right, let's move on. So we are able to back up every single thing we do in the Bills of Exchange Acts and the Uniform Commercial Code in the United States. So a lot of processes out there teach to use negotiable instruments, bills of exchange, promissory notes. Some of them have you, create your own voucher and like do a whole perforated line and put on like a treasury routing number or some crazy thing. We don't do all that. Negotiable instruments after the Emergency Banking Relief Act are the only real form of money that there is left. So we don't have the standing capacity to create money. That was ceded, that power was ceded by us through our representatives to the central banks. So we don't create negotiable instruments. Rather, we wait till they send us something, like, for a court case or a tax matter, and then we're able to finalize that instrument in a very particular way, the way a bank would do it, return it to them. And that is the type of negotiable instrument we use. Not to go into too much detail about the actual process of it, but it's a very specific way, the way a bank would do it, and it is readily accepted. Now, of course, they're typically going to push back and argue with you about it, and so that's where standing on the rock comes in. We teach you how to hold fast to what you're doing, how to compel them. We actually have some enforcement mechanisms that we're going to talk about in just a moment. And all these things basically just seek to eliminate the controversy and force their hand to follow their own laws. So courts are banks, as we're going to examine in just a moment. We're going to look up the definition of bank and show you that they just come right out and say it. Courts are banks. The judge is the banker. Courts issue you negotiable instruments. These negotiable instruments have all the fundamental legal qualities of a very particular type of instrument. It's used in accounting every single day between banks, millions of times a day. And so we are able to follow the commercial laws surrounding those types of instruments. And because courts have a financial interest in every matter that they see, they are bound to follow those commercial laws. The equity comes in to stop you from contracting with them in other ways. As I said, creating controversy is a contract, an adhesion contract. Arguing, fighting, hiring a lawyer, trying to teach them the law, even citing their laws itself is an adhesion contract. It all creates controversy and places you under a general appearance and causes all aspects of the case to apply to you. When we bring equity, we don't open up any of those doors. We appear specially, not to challenge jurisdiction, but to just settle and close the matter as an accounting matter and let it be done, be left alone. So courts are assuming you to be ignorant of, one, the fact that everything's a commercial matter, and two, that they're adhesion contracts that they don't teach you about. Court is all about hidden contracts with hidden rules, and then they penalize you for not following the rules that they didn't tell you about in the first place. They're just assuming that you're going to show up and argue just like everybody else, and you're going to challenge jurisdiction or submit filings and all the rest of it. Meanwhile, everything you submit, everything with your signature on it, is being entered as a line item on an account and being used to justify the bonds that are running on the case. The longer the case drags on, the more money is made. The more filings they get you to submit, the more money can be made on the case. And then, of course, when your filings ultimately cause the case to not go in your favor, then they make even more money off of attaching judgments to you, or perhaps, God forbid, ginning up penal bonds for somebody sitting through prison. They say money doesn't grow on trees, but of course, these paper negotiable instruments are the only real money there is left. They cut them down and print on it and send it to you every single day. And they never tell you that those pieces of paper can be turned into valuable money just by endorsing them in a very particular way. So in the modern day, money really does grow on trees. And it's been that way for almost 100 years, at least. Actually, longer than that outside of America. So this is kind of how the process works. The court or the IRS or the CRA or the ATO or whoever it is that you're dealing with, they're sending you instruments that very much look like drafts. They satisfy all the fundamental legal components of a draft. And it is incumbent upon you to accept a draft as it is presented, not quibble with them about the terms of it, not do conditional acceptance, or any of the other methods by which people try to negotiate the terms. You just accept it on its face. That keeps you in honor. And then we go a lot deeper on this in the class, but there's a whole process that's backed up by the Bills of Exchange Act and the UCC that essentially, once you accept and return that draft, they are forced to apply it to the underlying account and settle and close the matter. Now, of course, they're not going to do that just right away. 99% of the time, they're going to push back, and there's a whole lot of other things that we do that come into play to bring out methods of enforcement and prick the conscience and ask very, very hard-hitting questions and assert certain things. So very, very important to work the entire process and not just do a little bit of equity. But fundamentally, in a perfect world, this is how the process would work. You wouldn't need any of that other stuff. They would just accept your acceptance right away. Now, if you don't accept a draft as it is presented, then you're in commercial dishonor. and you can be prosecuted more for the dishonors that you commit than whatever the actual charges they're claiming are against you. The charges are just, they're just the account. I mean, that's just how they began the account in the first place, but it's how you conduct yourself commercially that determines whether that account keeps running or not, and in what way it keeps running. It can be run against you, or it can be closed, if you act right and you perform correctly. So if you don't perform correctly, you're in dishonor. But you need to accept the draft, and then you'll remain in honor. And of course, they'll be the ones in dishonor if they don't apply your acceptance to the underlying account and create discharge. Now, we work with, the certificate of dishonor, or sometimes called a protest, is a part of our enforcement process. I don't want you to get confused and assume that there's any similarity between what we teach and what's called the administrative process, because other than that one document, and we do ours in a very different way, there's no similarity there. The administrative process is very argumentative. So yes, they also use certificate of dishonor, but they use it in a very different way than we do. That's just part of our enforcement process. It actually goes a lot deeper than that. There's a much higher level aspect of our enforcement, and not just in America, but across the Western world. We're able to take it to the very highest level, to where you actually publicly memorialize the dishonor, and it's fully justified, and you can use that to actually create an enforcement capability, because it affects whoever's dishonor you're memorializing. It'll affect their credit score. It'll affect their insurability. All public servants are required to be bonded and insured, and bond providers are regularly checking the systems that we use for our enforcement procedure. And as long as you have a properly filed, properly justified enforcement process that has been perfected, as long as you have that, then it will touch those people on a personal level, and cause them to rethink their dishonor and actually go ahead and perform their duty and discharge the case. Now, there are a couple caveats there. I mean, it needs to be a properly perfected process. And I'm not going into a whole lot of specifics on this, because it can be dangerous. And there's people like Chris Hauser, that have gone to jail for doing stuff like that. I'm talking about UCC filings, but we take it to a higher level than what you may be familiar with. If it's not done properly, then it can be highly illegal. If you're not able to stand on what you're doing and actually justify it, then it's completely in error. And honestly, they are justified in prosecuting that person if so. Every security interest, which is what a UCC or a PPSR filing, or whatever the case may be. PPSR applies to Canada, Australia, New Zealand, etc. Whatever the case may be, it requires three fundamental components. So you have to have a valid security agreement, which is the hardest thing to get, and you have to have value and consideration. So value coming in one direction that you're giving the other person, and something they gave you. As far as I know, there's no other process out there that is able to justify meeting those three fundamental components of a security interest or a lien, even though what we're doing is not technically a lien. We're the only ones I've ever seen that actually search that out all the way through the UCC or the Bills of Exchange Acts, and fully provide justification. There's a lot of pushback people are getting now for doing this enforcement process and their other patriot processes, and they don't know how to defend it, and they just tell their students, oh yeah, just file a lien on the judge, or do a PPSR on the judge if you're in Canada, and they won't want to mess with you. And if the person doesn't know how to actually justify, where's the security agreement, where's the value, where's the consideration, why did you file this, then the filing can be unmade, and that person can be criminally prosecuted. So it's not strictly necessary for bringing equity, but it is a very powerful tool if you can stand on it, if you can justify it. And we're the only ones out there that can teach you how to actually stand on it in a way that will hold up. So that's one thing that really sets us apart. And I can tell you right now, you're not going to find that anywhere else. It's, as far as I know, and I've seen a lot, we're the only ones that even teach that. All right, let's look at some definitions. These are fun. These are from Black's Law Dictionary, the 6th edition, which is the best edition. And we're going to look at bank, just to kind of back up some of what I've been telling you. Bank says, a bench or seat, the bench of justice, the bench or tribunal occupied by the judges, the seat of judgment, a court, the full bench or full court, the assembly of all the judges of a court. So really just coming right out and saying it. The court is a bank, the judge is the banker. All they're doing is handling transactions. And I mean, if you ever showed up to court for like a credit card debt or something, I mean, they're just passing out judgments like a bank teller. I mean, just, oh, payday loan judgment, for this guy, for that gal. It's kind of pathetic, honestly. To be a judge and have gone through that whole career, and then you're just passing out judgments for payday loans all day. I mean, it's terrible. Um, but yeah, we teach you how to go before those judges and get your credit cards dismissed. I mean, there's credit cards are the easiest. Next one, equity courts and law courts. Under rules of civil procedure, equity and law have been merged at the procedural level. So this is why it makes no sense to try to like get yourself in chancery court or do all that pre-1933 equity stuff, commonly taught by. Well, I won't get into all that. Under rules of civil procedure, equity and law have been merged at the procedural level, and as such, this distinction no longer exists in the federal courts, nor in most state courts, though equity substantive jurisprudence remains viable. In other words, you're going to show up to their commercial courts, their admiralty maritime courts, but you're going to be able to bring equity. It's still jurisprudentially viable. Statuable or statutory. That which is introduced or governed by statutory law as opposed to the common law or equity. So when you see the word or in a definition, you can just treat the word or as a period. So this is differentiating commercial law from common law, and it's also differentiating the two of those from equity. Equity is its own separate jurisdiction. And as we're going to see in the definition, at law, particularly in distinction from that which is done in or according to equity. So one of the synonyms for the word at is the word near. So, you might see attorneys with their billboards around town, attorney at law. Well, I just say attorney near the law. Equity is in contradistinction to that. Equity is in the law. Equity is the highest form of law. So that's an important one to remember. Very fine line between statutory and commercial law, and I can even just lump in common law with all that because it's very commercialized in the modern day. Very fine line between all of that and equity. One who seeks equity must do equity. So you can't be 1 foot in, 1 foot out. Equity is very forgiving. It is very morally upright, and for that reason, it is forgiving. But it's also very special and specific. So thinking that you can do a little bit of equity is not going to do anything but confuse the court and cause you to look double-minded. They'll probably order you for a psych eval. You can't just glean equity from a couple of YouTube videos and think that you're going to be able to bring it to a case. You have to have somebody walk you through the ins and outs of court. There's a lot of just plain commercial aspects of court that not even to do with alternative law processes that you need to know. And this is stuff that we spend a lot of time teaching our students too, is just how court functions. Excuse me. What sort of arguments the plaintiff or the prosecutors are going to be bringing up and why it doesn't apply to you for a number of different cases out there. How did you get yourself into this mess? What contracts did you agree to? It gets really intricate. And so even before you get into alternative law processes and how to point out what they're doing in the darkness and get them to discharge the case, there's just a lot of procedural stuff and a lot of doctrinal stuff that you need to know in order to kind of hold your own in court and not be caught off guard by something. So these are things that we walk through with our students, just added value that really will help you stand in confidence and be ready for anything that they can throw at you. And we've seen it all. I've watched over hundreds of cases at this point, and had many interactions with judges, and um, we can walk you through the A to Z of every single case. Doesn't matter if it's the federal level or the state level. We're extremely experienced in that. So even just beyond finding somebody to teach you an alternative law process, we're actually going to be able to walk you through the A to Z of everything. Now, on top of that, we also have the most powerful remedy out there. But it cannot be mixed with anything else. And there's a lot of trial and error that went into the development of this process before we even came along. I mean, book knowledge and head knowledge does not equate to proper application. Just because um, you listen to like 4 years worth of Christian Walters videos, and you took a class with Rourke and Phelps, and you've gleaned as much of our material off of YouTube as you can, doesn't mean that you're actually going to know how to apply it in a court situation. I mean, Christian Walters and Rourke and Phelps are amazing teachers, like great historians, and break things down in a way that tie it into scripture and the Black's definitions that really resonates in a deep way, but they don't teach practical application. And I mean, you would basically have to take everything you learn from them and then do like 10 years of trial and error with people that are just willing to let you have at their cases, even though you don't know what you're doing. And if you do that, if you can find those volunteers, 10 years later, you might come up with a substantive process that has, a viable success rate. But we can just eliminate all of that pain and suffering, all those years of trial and error, and just walk you through the whole process in 4 months. And at the end of that process, at the end of this class, you can be untouchable as a defendant in any area, in property taxes, business taxes, income taxes, criminal court cases. I mean, foreclosures. I mean, you name it. We've taken on all of these things. There is a 100% success rate in what we teach, but you have to actually commit to it and learn not just the head knowledge, but the actual practical application. And we're one of the only classes out there that actually does both. Another very powerful thing that equity is capable of doing is they say equity can time travel. Well, what does that mean? Uh, Equity is the only jurisdiction that allows you to treat matters that happened 10, 20, 30 years ago as if they were just happening yesterday. What I mean is there's no statute of limitations. Um, there is that old maxim, laches defeats equity, meaning delay defeats equity. But there's actually so many powerful equitable remedies built on top of this jurisdiction since that maxim came about that really make it irrelevant at this point. Maxims don't just stay rigid throughout the centuries. I mean, they evolve based on case precedents. And there are remedies within equity that allow you to actually go back and unmake a contract as if it never existed. So some of you are interested in the right to travel, or unmaking the birth certificate account, or unmaking the social security number. Um, that's a harder life, but equity will give you the tools that you need to be able to do that. Most of you are more interested in being in the world but not of it. Being able to operate in commerce with the social security number, and start a business, and provide for your family and all that. But you just want to be protected. And the business world, unfortunately, requires you to enter into contracts sometimes, especially in more heavily regulated industries, enter into contracts with the government. And these can provide the basis for court cases to be brought against you. And so we actually give you the power to unmake those contracts, and that will go a long way to getting the case dismissed. So it's a very, very powerful remedy in equity that allows you to do that. We go in deep into like the whole process of how that's done. It's very particular the way that you would do that. Sometimes some of you had people sign contracts for you on your behalf. If you ever hired an attorney, I'm sure the attorney signed something on your behalf. Well, it still counts against you. So there's ways that we can even unmake those things in equity, even if you weren't the one who actually signed. Well, that's always the case for the birth certificate and social security number, right? You're just a baby, but we can still unmake those for you if you choose to go that route. And there's also, not just contracts from long ago, but say you've had like something from the CRA has been sitting on your desk for like the last 2 years, and you just haven't had the courage to just pick it up and deal with it, because it's a scary prospect. There's an aspect of our documentation and equity that allows you to treat those things as if they are recent, and you can actually. This is another reason why they say equity time travels, because you can deal with things that have been kind of festering for a while as if they just occurred. We go deep on that in the class. I'm not going to describe too much of the process on that, but just so you know that there is nothing coming against you that equity cannot take care of. Doesn't matter how old it is, doesn't matter how long it's been bothering you. There's nothing that equity is not going to be able to deal with for you in your life. Um, in any situation where somebody's coming after you for something or demanding something of you, equity will be able to solve the problem. All right, so I want to get into some. I want to touch on the spiritual component of what's going on with the court system, because we can talk about process and head knowledge all day long, but before things manifest in the physical realm, they are present in the spiritual realm, and really doesn't matter what your belief system is. These are just going to be some fundamental truths that I know will resonate with you. Um, so let's take a look at the history of what's going on here and what happened in the spiritual realm, and how we got to this place. I've had a lot of phone calls, and I've heard a lot of testimonies from people in the Patriot movement, hundreds, far more than I can count from memory. I've heard a lot of testimonies of incredible miracles that people witnessed while they were imprisoned, while they were dealing with the court system. I mean, just supernatural encounters that wound up bringing them to Christ and setting them free, and actually, getting their cases dismissed in many cases. I've also studied secret societies across 6,000 years of history. As best as I can tell, the kings of the earth have a deal with the spiritual realm. Not a deal with God, though they do have to follow some of his laws. Their deal is with the Watchers, or the Grigori, whom some of you know as the ones who gave birth to the beings the Sumerians called the Anunnaki. The kings of the earth were given a court and prison system which persists to this very day. This is why the judge wears a black Saturnian robe. This is why secret societies pay lip service to the Bible while mocking God's laws and inverting his word. Their court and prison system is, in effect, a spiritual crucible, a fiery crucible which they put anyone on the fringes of society through to make or break them. Many don't make it through. Many don't come out refined. But we serve a mighty God who is quick to save and who lends incredible power to the faithful. Our God is close to the brokenhearted. Even if somebody has to make their bed in hell, God is always near to them. And this is why so many people in prison experience supernatural miracles. It's because of their desperation. This is why there are so many incredible testimonies of evidence being destroyed that leads to our brothers and sisters being set free, like Katie Souza's story, or wicked prosecutors dying the night before a crucial hearing, like Abraham Bolden's remarkable story. When we get desperate, God moves in power. I can tell you that we have witnessed incredible miracles with this equity process. It is based 100% on Scripture, and it honors God just as it honors everyone else you interact with. In His great mercy, God has used this process to set people free before they enter the crucible. We have seen people hauled off for sentences of years in prison, only to be released an hour into their sentence. It's because the judge made a special call to the jailer. The jailer actually opened the door and said, "Hey, the judge called. Your case has been discharged. You're free to go." We've seen people escorted out the back door of the courthouse and shoved out the door and told, "Don't you ever come back here." We've seen so many people delivered from bondage, and God just keeps giving. He truly loves this process because it is based in honor, repentance, forgiveness, and the silent power of His authority, which He grants to the humble but denies to the proud. We are the vanguard of His army in the Western world. We pull people from the jaws of defeat using strategies that have been hidden in plain sight for millennia. If you'd like to join us, we can teach you how to free yourself and how to free others too. So I'd like to talk a little bit about the class. We run for 13 weeks in the equity class. In a couple weeks, we're going to come back for another session of this workshop. We'll talk about our other class about creating trust systems and operating businesses and commerce and all that. But to just touch on the equity class, we run for 13 weeks. It's capable of making you untouchable as a defendant. We do court role play in the class. We have so many experiences in court that we're just able to simulate an actual experience for you with like an angry judge, or a hothead judge, or maybe just a judge that plays dumb. There's a lot of different tactics they use, mind games that they employ in court, and we're familiar with it all. So we run the students through some pretty rigorous court role play. We have just a treasure trove of study materials to keep you busy when class isn't in session. We have a highly active alumni group with hundreds of people in it. They're all at various stages of bringing equity to their lives. There's always testimonies coming out. They're always sharing their documents with each other and asking for critiques and improvements. There's a wonderful community of people supporting each other. I like to just discuss a few testimonies as well that we've had recently, just in like maybe the last 3 months or so. We had a big civil case in Ontario that's been going on for like 2 years. And this woman in Ontario, she just found us about 3 months ago. And they're just harassing her for years because of her chickens. They say, "Oh, you can't have chickens, you can't have roosters. This is a nuisance to the community." Even though, the neighbors all have barking dogs all over the place, but who cares about that? We just can't have roosters and chickens because God forbid you actually provide for yourself. So they were harassing her. There were people coming from the local government coming and peeping in her windows and writing up stuff, and her neighbors were very supportive of her, but she had this one neighbor that was kind of egging on the situation. Anyway, she did the equity paperwork, and within 3 months, they scheduled a trial. She finished her paperwork, and she shows up for the day of the trial, and all charges have been dismissed. So that was awesome. And so now her chickens are back in the backyard, and they're thriving and happy again. And they were going to take her through a whole trial and everything, and potentially lead to penalties against her property. So that was a big deal. And there's so many cases that we've dealt with where like local governments are just power tripping and overstepping their bounds and trying to force people to do things that they have no business forcing. And equity is always able to come in and provide a remedy. And so that just shows that even in Canada, there is remedy. We just discharged our our first mortgage case recently. And when I say first, I mean, it was just the first person that was actually willing to go through the whole process and apply it to a mortgage. So the first person that was willing to do that, we discharged their mortgage for them. It's been almost a year now, and the case has just gone completely silent. Multiple credit cards in the last 3 months, amounts $20,000, $12,000. The credit cards are easy. I mean, at this point, Just like, okay, if you can't afford the class, just put it on a credit card. I mean, it's so easy to discharge credit cards in equity. Um, it can go on to become a court matter, but I mean, we prepare you for absolutely every possible outcome. So at this point, I mean, I have the utmost confidence, even if somebody isn't like bringing equity that well, they still are able to discharge credit cards. So it's really um, that one's pretty simple. We just had another student discharge a big hospital bill. That's many times that's happened at this point. Another student received a certificate of release of federal tax lien from the IRS. We've seen IRS debts discharged, multiple ones just in the last few months, and then over the entire course of what we've been teaching, I can't even count all of them. They actually get paperwork back saying $0 balance or no further action is required on your account. And it's not enough just to get one of those letters. You want to see them come from multiple IRS centers, because usually they have accounts in your name running at least 2 or 3 different IRS centers. And so we don't even claim victory on those cases until we get multiple letters coming back saying that, and the IRS truly leaves the person alone. Several of our students have gone on to teach others, and they're having their own successes. Good teachers make other good teachers, right? So we have a small handful of students that have gone on to help others, and seen their own successes, discharged IRS cases, and other things. I can also play a couple of testimony videos if we have time for that. Just a couple of quick ones from a
Yeah,
couple
go
of our
for it, Julian.
students. Awesome.
You probably have to reshare with sound to make sure that the audio comes through.
Next testimony I want to play is from a student of ours named Amy in Australia, and she has just been a total firebrand with this process. It's incredible. Like she's like, I'm done with all this commercial crap. I'm just going to bring equity to everything in my life, and she's seen some incredible success down there in Australia. So I just want to play this video from her.
Welcome everyone. My name is Amy Brax. I'm here by a special appearance, not a general appearance. You will know what that means later on when you do the court script. I am forever grateful for the path of equity, and I only have 2 minutes to explain the wonderful path of equity, which is going to be very difficult because I'd love to tell you all the success and the story that brought me to that, but I don't know if I'm going to have time. So I will just say that I was at ends meet in housing for domestic violence, brand new baby during the fake virus. Businesses were closing down, loans I couldn't pay, and then I heard the call of equity, and I searched for a teacher that could teach equity, because I knew in my spirit and my heart, without even knowing what equity was, that equity was the path, and I no longer had to waste all those hours on Zoom calls being promised so much, all of the money invested in private trust that took me nowhere. Equity, when we learn it through Julian and Maggie, you learn the start, the middle, and the end. All the notices are the same wherever we go in the world. So we have a very high bar of how we do our notices and how we keep it the same so it's recognized worldwide. The beautiful thing about equity with Julian is he teaches you the end game, how to stand up for yourself in court, which is a life-changing thing. I've been to court 5 times now, and I've had tremendous success. I've discharged all of the court fines that were connected, a car loan, 3 massive business loans that I had, small credit card, childcare fees, and now I'm starting to go on and really clean out my house, getting rid of these big overheads like Optus bills, closing the accounts there, Zip Money, these little smaller sort of, it's like a parasite that's just incurring interest. I'm putting to bed those, and I'm really cleaning my house. The beautiful path of equity has led me to Christ, has led me to salvation. You don't have to be a Christian, but spirituality and faith will definitely come through this path, because we need to be rock solid in being warriors to lead the people out of Her and Babylon. And if you're not ready for that challenge, then just do it for yourself, do it for your family. But there is a strong spiritual component to this course, and for good reason. You know, when we go deep into the Bible and we see the commercial codes of unlocking them through the Bible, it really brings us to prayer every time we do the notices. It has restored so much honor and integrity into my life. I used to fight and hate the administration and hate the corporations and really be at war. I've found peace. I've learned how to bring notice of inquiry and honor to my landlords, to my children's school. Wherever I go, I have a remedy through one of the notices to stand on the rock, and also to not live in fear of fiat, which is the greatest blessing. I've got to a point now where I sit down at my desk, I do my notices, and I don't have any thoughts in my head that say, will this work? It's taken me 2 years to go there. I've had a lot of doubt, a lot of roller coaster through this path, but somehow I've come to a point now where I know when I accept it, it's discharged and the matter's closed. So I come in full faith and credit now in this beautiful path. But yes, I do dedicate at least an hour a day to listening to the recorded videos or tuning into the new groups. I want it to be a lifestyle, and I'm a dedicated student. It is the number one path. It's what unlocks all of the issues we have and starts to settle and close them. I am forever grateful, and I really pray that you guys get onto this course and bring equity into your lives, into your matters, so you can rest your head easy at night, knowing they're not going to knock down your door or take your house, or take, you know, your house from where you lay your head down at night. I pray that you all find what you're after in this course, and I'll see you on the Telegram group. I'd love to share with you all, help you out, and maybe get some advice from you moving on. God bless.
Beautiful. Yes, as you can see, I mean, it's great for matters big and small. I mean, she was even talking about just applying it to, you know, her children's school when they're trying to, you know, introduce some crazy teaching that goes completely against you know, human decency. You know, whatever the case may be, I mean, equity is going to provide a remedy and just give you some incredible tools to compel performance from anybody that's coming after you or trying to force something on you. So these are the ways you can get in touch with us. Our website is standingontherock.com. You can email us at standingontherock@tuda.com, or you can send me a message on Telegram. That's the easiest way to get in touch with me. And that's t.me/vitiate0. So that's the number 0 after that. And then the website, of course, is going to have more enrollment details for the classes and everything. It's standingontherock.com. So, is there anyone struggling to grasp the liberation that equity employs, or does anyone feel like I maybe left an empty loop that isn't allowing you to connect with why this problem?
You muted yourself, Julian.
Sorry, Julian. I think I accidentally muted you when I was changing the settings. My
Oh, that's
apologies.
all right. That's fine. I'm just asking if anybody is thinks there might be an open loop or you know, something that I might have missed that is preventing them from understanding just the incredible power of this. And of course, any other questions that you have, I'd be happy to take.
So we're going to ask, so first of all, let me just jump in. Amazing, great. I love the upgrades to the presentation. I first saw this probably more than a year ago, the first time I saw it. And I really appreciate how you've kind of dialed it in to be even sharper since the first time I saw it. So appreciate that. And
Thank
yeah,
you, David.
I mean, great stuff. My testimony is I've already discharged one obligation. It wasn't a big deal, but it was it was basically, you know, by the process, and it felt right the whole time, and it ended well. And I've got some other stuff going on, and of course, I'm seeing a lot of the secondhand testimonials that other people are sharing with me, and two of your other alumni, Julian, Aaron, and now Amy, the same Amy that we just heard from, are actually now advisors on our team as well. In other words, they can meet with people privately in consultation through our organization. So that's also a big testimony right there.
Yeah, it's awesome.
So, folks, if you wouldn't mind raising your Zoom hand if you want to ask a question, just so we can kind of maintain an order. We want to give everybody a chance to ask a question. Of course, if you can turn on your camera, that'd be great. We'd love to see who's asking. And we'll just take them one at a time and see what comes up. So let's go to Joe Clemens. Joe, with your question for Julian.
Hi. Hi, thank you so much, Julian. That was a wonderful presentation. I'm not new to equity, but I love the details. So my questions are, can we apply this process to recurring bills like water bill, electric, phone, or is this more for the debt incurred for credit cards, mortgage, car loans?
Well, it's for all of that and even criminal cases. I mean, basically anything that somebody's coming after you for. But when it comes to recurring accounts, anything that you're asking for a benefit or a privilege on, for example, you're asking the power company for their electricity, you're asking the water company for their water. That's going to be a situation where they have quite a lot of leverage. They're not really quite as interested in your money as they are in controlling you. So we've had some students that brought equity to those matters and seen their bills reduced or just zeroed out, and the service was never canceled or anything. And we've had some students that brought equity to those matters and they get a lot of pushback. And of course, if you're asking them for a benefit, then if they decide to push back, there's not a whole lot you can do about continuing to receive that benefit. You can discharge the amount. You can jack up the bill for a year and hold off paying in dollars and then discharge the whole thing. But
Right. Okay, so
there's
it sounds like it's sort of hit or miss, right? Which I understand. It can be used, but hit or miss, which is fine.
well, it always hits in the sense that it'll discharge the account, but if you're asking the government for a benefit or a utility company for a benefit, they can just
Oh, right. They may just not contract you for electricity.
right.
I get it. I see. I see what you're saying. And then the other question is, if there is a criminal case that was in the past, is there any way to re-engage for any kind of equity, or would this just be ongoing in future criminal cases?
Absolutely. There's a way to clear the record, and there
Really?
are several people that have done that yet. Where you can treat anything that's happened in your life as if it is occurring presently, um, in equity. So as long as you apply the process, um, then you can basically in effect reopen that case and get the case discharged. And there's a maxim that states that equity will do what ought to be done. So now that you understand what ought to be done on the case, you can see it done.
Oh, excellent. That's really good news. And then just one more question. I think I know the answer, but I'm pursuing a few things. So what I don't understand about equity is if someone trounces on your rights, which I've had a case recently, in my mind, I need to file a claim. I need to write them a letter or something, but I need to initiate it because it's something that happened to me. But I'm not quite sure because it seems like this isn't, if we're filing a claim against someone, it has to be we're the
Yeah,
defendant.
equities for making you untouchable as a defendant. So it's not about going after our brothers and sisters. Of course, people are wronged all the time, and there's other processes for plaintiff actions. But what we teach is simply for being left alone,
Okay.
for being untouchable as a defendant only.
Thank you. Appreciate it.
Absolutely.
Whoops, I
Yeah.
realized I was muted. Let's go to Saifullah with your question. Go ahead. You'll have to unmute yourself.
Hey, how's it going?
Hey,
Good. How's
David.
it going, Stefan?
Pretty good. I just had two questions about using equity as far as purchasing a vehicle. Is that possible?
So we've had students discharge car loans. It actually tends to be a lot easier in other countries other than America, because in America you have the whole issue of vehicle registration, which has been locked down. In Australia and Canada, it's actually a bit easier for that reason. But in America, you can, it's not for purchasing the vehicle, but if you take out a car loan, you can discharge the loan with equity. Now it's a more involved process in America because you're probably not going to be able to get clear title to that vehicle.
Yeah,
Um, but I did mention how we even have solutions for people that are interested in the right to travel, that don't want to drive with registration and identification and all that.
mhm,
It's a harder path because anytime you get pulled over, you're going to have an issue. But equity will be able to discharge anything that comes against you from making those choices. So if that's something that you want to stand on, um, obviously you're going to have to stand on that if you have a car that can't get clear title. So you can take out the car loan, get the car, use equity to discharge the loan, and then you're going to have to stand on the whole right to travel thing and just not get a registration for the car, and just use equity to discharge any what we call offers that might come your way from a roadside warrior pulling you over.
and would you do the traditional down payment and then running your credit?
You would have to do that. Yeah, they're not going to give you the car if you don't do that.
Yeah. Okay. So do you pay the first payment?
I mean, you don't even have to go that far. No, I mean, as soon as the car is in your possession, then you have equitable title to the car, and from that point on, you can stand on it. It's like I said, it's a little bit more involved process because first they're going to put you on a repo list. How do you deal with those people? And we have
Yeah,
solutions. We have solutions for all of that, but
right.
it's a little bit more involved in some things.
Got you. All right. I appreciate you.
Yeah, no question.
Awesome. Awesome. Let's go to Brad K with your question.
Hey, thanks again. I've really been enjoying this. My question is for a friend who lost his home earlier this year to a foreclosure. I know you just said that equity doesn't go on offense, but could equity be applied for my my friend who went through and lost his home?
So there is something called equitable redemption, which is a remedy available in equity. It can, from what we've been told from the people that we learn from, it can take quite a long time. I haven't had somebody commit to going through that whole process with us yet, but it's fairly straightforward. And we're told by some of the people that we've learned from that even post foreclosure, after the house has already been seized, they don't even learn about equity till like 2 years later. They were able to go back and not get the house back, but get a check cut to them for the value of the house.
Oh, okay. Interesting. Um, all right. So nothing direct on foreclosure, but we've heard of it secondhand. What I mean direct, no direct knowledge, but secondhand knowledge from you.
Yeah, well, when it comes to like, during a foreclosure, yeah, we've discharged those
Oh,
cases. But
yeah.
but after a foreclosure has already gone through, the person's been removed from the home. It's been like 2 years since they've even lived there. What we've heard from the people that we learn from is that, they've seen cases where even in those instances they could be cut a check at the very least. But in active foreclosure, yeah, I mean, we have direct experience with that. So
Beautiful. All right. Hey, I appreciate that. Thank you.
absolutely.
It looks like Sonia has a question, but you have to unmute yourself. We can't do that for you. Unfortunately, Zoom doesn't have a feature where the host can unmute someone. That would be a great feature to add.
Can you hear me now?
Yes.
Hello. Oh, hello. I got on a bit late because my phone didn't tell me the time. I'm from the Gold Coast, Australia, and I'm super excited to be here with you people. And the most exciting thing is that I believe in God and Jesus, so I'm like super excited. And I feel like God like totally put me with you guys because for years I've always thought this system is so corrupt and there's something really wrong with the whole thing. And I want to exit it. I actually feel like I want to be one of the forerunners who actually totally exit Medicare card, Social Security. I'm like, this fake birth certificate, I want to be totally like out of that. My parents signed me up to something I never agreed with.
Yeah.
But a quick question. I want to know, can we access our monetary bond from the birth certificate that is held, I think, in the Treasury office? And also, can we put our properties, like whether it's rural block of land, into a trust? Because I tried to do it here with a Christian fellow that was a tax agent, and he told me, "Oh, you've got to pay all this money. You've got to tell the government that you've got to pay all this capital gains taxes," and he didn't have a clue what I was talking about. What do you think, Julian?
Great question, Sonia. Appreciate it. It's kind of funny, a Christian tax agent. It's kind of an oxymoron, right? You know,
He doesn't know.
Jesus called a
Yeah,
tax
he's
collector out of
fine. He
that.
doesn't know yet.
That's
He's not
funny.
awake yet.
Okay, I'll deal with them one at a time. So the first one was, can we monetize our bond from the birth certificate account? This is a very popular teaching out there. It's kind of mixed in with the whole secure party creditor thing. Sometimes it's treated as its own just individual status change process. Um, so my we showed kind of a few maxims of law earlier in the presentation, which you might not have seen, which just talks about how things that you have long acquiesced in, you're not injured. There can be no injury that's done to you in the contracts around those things. Things that you consent to is what makes the law. So when you consent to the birth certificate and the social security number, and then you begin to, or the Medicare card, you begin to perform on those contracts by using those things to open bank accounts, get driver's licenses, etc., then those contracts have really stuck. Now, unsticking them is something that we can help you with in equity. We have a specific
Awesome.
remedy that goes back and unmakes those contracts as if they never existed. But as far as accessing any monies tied to those accounts, we discharge against those accounts in equity. Like if you ever get a court case, that's really the prevailing theory of what's going on, is that, when we issue our particular type of negotiable instrument, they discharge against that birth certificate account, but it's them that has to administrate that. It's not your account to directly access. There's nobody that's actually ever monetized the bond from their birth certificate account in any way other than that. So just bringing
Okay.
equity. If they were, then there would be evidence of that somewhere, but there is no evidence of that, and none of the people that claim that you can do that have ever. What they say is,
Done.
"Oh, well, I did it, and I signed an NDA though, so all I can do is really just give you like cryptic little hints." Okay, so pay me some money, even though I'm rich, I'd still want your money, and maybe I'll give you some breadcrumbs, and you can just kind of chase your tail for 2 years. Yeah, that's my opinion about that stuff. But I mean, really, you have an incredible amount of power in the role that you've been placed into through the birth certificate. You are a surety in that role, but the power of equity is available to you in that role. Now, if you want to unmake those things, that's awesome. More power to you, and we can equip you with the tools to do that as well.
That'd be
So
great.
yeah, it's like whatever path you want to take, equity is going to give you the absolute best tools
I just
to.
feel with the digital ID system that I actually feel like I want to be free of all that stuff. I don't fully understand how I would survive, but I believe God's bigger than their monetary system.
Amen.
He's
Yeah, I
he's,
mean,
he's sovereign.
Elijah was fed by crows, right? So I mean,
That's it.
they'll come
Yay,
up with a
that's
way for
right.
you to be provided for.
Hello. The fish can have the money in the fish's mouth. Like we can trust God with everything. He's got a solution. But I think he's awakening people.
Amen. Amen. Yeah, it's a beautiful way to put it. Yeah, and I totally agree.
And the final question was just about putting property into a private trust.
Oh,
How do we
yes.
do that too?
So in part two of this workshop, which we're going to have in 2 weeks from today, we're going to talk
Awesome.
about our whole other class, which is all about that subject. And we have several students from Australia in that class. Trust law in
Awesome.
Australia is quite a bit different from Canada and the US. So there's some very unique aspects that we dive deep in on that class. And it's been very effective in Australia. So we can teach you how to set up a whole private trust system, but then also, have a proprietary limited if you're in an industry that needs to do that. It just depends on what you have going on. Like if you're in a more heavily regulated industry like real estate, you may need to have that corporation at the surface level. But we can do it where it's totally isolated, it's not attached to your name, and then it feeds the profits down into a private trust system that you control. And it just
Awesome.
depends what you
So
want to
can
do.
you send me a link to join that particular classes?
You're already enrolled, Sonia.
I'm
You
already
just have,
enrolled. Okay, wonderful.
it's a
Oh, God
two-part
bless you
series.
guys. Oh, I just feel like, I just feel like so happy. This is amazing. Honestly, you people are beautiful. I'm just so happy today. Thank you.
Thank you,
Thank you,
Sonia. Thank you for your
Julian.
support.
You're
It's our
amazing.
pleasure.
I'm excited.
Awesome. Okay. And Andreas was asking in the chat about applicability in Germany. I don't know if you want to speak to that, Julian, at all.
So we have not had a German student yet. I would love to have a German student. I mean, we really take a lot of joy in applying this process throughout the world. We've adapted it to Ireland, to the UK, to also, of course, Australia and Canada have been the biggest so far. We have students in New Zealand that we're adapting the process to, South Africa. Germany's going to be, a little bit trickier just because it's, a totally different language. But we have very powerful research tools that we can use to help you adapt it to Germany. And I know I've already looked up Germany. I know Germany has equity jurisprudence. And I would love to do it in Germany because you guys have it really hard over there. Your government is absolutely insane. So I would love to help you with that.
All right. Well, let's see if we get someone signing up from Germany. Someone else in the class asked about when the actual course starts. Did you want to speak, Julian, at all to the start dates and running time of the course?
Yeah, so these two sessions that we're doing here, these are just like preliminary workshops. So we're going to do the second one in a couple of weeks. And then for the actual full-length classes, the Honor with Equity class begins January 13th, and you can sign up for that at standingontherock.com. Or sorry, January 21st is when it begins. And we'll run Wednesdays at 7, probably actually a little earlier than we usually have, to be determined on the exact start time. But January 21st. And then the trust system class, you can enroll in that at standingontherock.com as well. And that will begin on February 10th. So, and that one runs for 12 weeks on Tuesdays.
Okay, great. And just to remind people, those are live classes, and you get access to you always, as a student, you get access to the replay, so you can keep going back and rewatching a class, whether you attended or not. Of course, attending, you're going to get more out of it if you can actually participate. Yeah, so just so you guys know. And I think,
Yeah,
Julian, you mentioned sometimes you have a break, like you don't necessarily run for 13 consecutive weeks. You might have like
right.
a break, right?
Yeah, we might take a week or two off here or there. Usually like a total of 2 weeks break or so. And also, everybody that signs up, I mean, you don't just get access to that live series that will run for 13 weeks. You get access to all future live series, and you're in for life. And then you have access to the recordings as well going forward. So, once you're in, you get access to everything.
And I've already taken honor with equity, I think 3 times if I haven't lost track already. So this is probably going to be the third or fourth time that I'm taking the class. So I can attest to that. Let's go to Dr. Latino with your question for Julian. Dr. Latina.
Hello, everyone. I enjoyed the presentation, so thank you, Julian. The question that I have is, do you offer, I know you just mentioned the 12-week and the 13-week courses. Do you offer like a consultation, just maybe for like, for any issue that might be pressing for someone that kind of needs some assistance right away? I'm interested in taking the class, but I have a situation that I really need some help on. So I
Yeah.
wanted to find out if you do like a consultation that I could talk with you offline about.
Yeah, absolutely. So anybody that has like a pressing issue that they're actively dealing with, we can actually set you up with the previous classes recording so you get caught up on that. And then in addition to that, we can work with you on just like a hourly basis to help you bring equity to that case. That way you don't have to wait to go through the whole class.
Yeah.
You can start getting caught up now, and we can, work with you. We can complete, paperwork for you. We can do court role play with you. We can walk you through like an overall strategy for the whole case and really just hold your hand through the whole process. It just depends how involved you want us to be.
Okay. So my question is, I'll just go ahead and ask you now. So I have a foreclosure right now that is in the redemption process, and it's um I want to find out how to avoid going to court. I don't want to go to court, but I want to also, I've already filed for UCC. I'm still learning this whole process of, sovereignty, but I want to make sure that I can just solve the situation by providing equity, not having to really go to court, but dealing with um, the bank per se and letting
So
that
you're saying
be.
the foreclosure's already gone through when you say you're in the redemption process, you're
Yeah,
already out of the house and everything?
yeah, I still have it, but yeah, I mean, before they start to want to take me to court, I want to avoid that.
Okay, so you're still in foreclosure. You haven't left the house.
No, no, right.
Okay, so yeah, I mean, you would probably have to unmake a lot of what you've already done if it's according to some other process. Um, other processes are just very hit or miss. Equity is the only thing with that I know of with a 100% success rate. So we're probably going to
Mhm.
have to walk you through how to walk back some of those things, especially if a UCC filing was made that's contrary to what we teach. It's probably not going to be defensible or
Okay,
justifiable. So we go really deep on that whole process. So you're definitely going to want to make sure that you're standing on the foundation that we provide. Is there's really, if you're going that far to UCC,
yeah,
um, our class is again, I mean, it's the only thing out there that is going to go deep enough for you to be able to stand on that no matter what comes of it. And there can
okay,
be some attacks against you for UCC. So you really have to know how to use it and how to stand on it. But yeah, we can help you with all that. It's going to be a very intense case. You're going to have to learn pretty quickly. Mortgages and foreclosures. You need to use all of the tools that we teach, and you need
yeah,
to use them to a high proficiency. So we can help you with that. But just that warning is that it's going to be a lot of work in a short amount of time in order to get you caught up to where you need to be.
okay. All right, do you have an email? I can just send you an email to get a hold of you.
Yeah, it's standing on the rock at tuda.com. I could throw that up again. Oh,
Okay,
and just to address the whole thing about court, we are going to just drastically and dramatically prepare you for court. I mean, it's going to be just incredible court role play that we do. We're going to have a whole script, but we're also going to teach you how to go off script because the judge is always going to go off script. We're going to teach you how to handle that when he does it. But you have to go to court. You have to show up to the place of judgment. If you don't go to court, you're not. I mean, it's like having a check in your wallet and you don't go to the bank to cash it.
all right, okay,
The court is the bank, the judge is the banker. We have to go to the place of judgment in order to get our remedies. So, but you're going to be a lot more confident about that once you've gone through the class. So, you're probably not going to feel the same way about it.
okay. Thank you.
I want to stop the screen sharing just so we can see each other's faces, but I'm gonna go ahead and write, can one of the moderators, Aaron, could you write all of Julian's contact information, his website and so forth into the chat, just so people can access it? Awesome. That's why I wanted to keep the screen share off because I want us to be able to see each other. But all right, here's a fun one, Julian. I mean, obviously we know the answer to this, but we might as well answer it. Ty was asking, can we not pay for your course with a negotiable instrument?
Yeah, I get that one a lot. So I don't have access to the Federal Reserve discount window. So the negotiable instruments that we tender are just, can discharge debts dollar for dollar, just like the remedy has been set up for us. But, it has to be with an institutional player that has access to the Federal Reserve discount window. So that's why it works with courts, hospital conglomerates, major corporations, banks, credit unions, etc. But personally, I don't know anybody at the Federal Reserve, so I wouldn't be able to do anything with that.
Not for your neighbor.
Yeah, like if your neighbor loaned you $20, I mean, you couldn't do an acceptance on it. I mean, that would be kind of rude because he wouldn't be able to take it to the Federal Reserve discount window. So he'd be just like, I'm not going to loan you money again.
Awesome. All right, Aaron, did you want to share something or ask a question?
No, I just wanted to point out that there's a question in the chat here that someone was saying, can you elaborate about the mandatory vehicle registration? They're from Canada. And then also, will equity help with claiming past mortgages or securities? Those are in the chat.
So I think I've already answered the second question. The first question, just elaborate about mandatory registration. I mean, there's some jurisdictions outside of America that allow you to just pay a fee every so often instead of registering the vehicle. I know that's the case in Australia, and I'm pretty sure there's an equivalent in Canada. It's just been a while since I've looked at one of those cases in Canada. But that's what I meant by that.
But in the US, it's not that way at all.
Yeah, in the US, it's just like totally locked down. I mean, the American people lost the battle for registration decades ago. And for some reason, the Australians are like, yeah, we drive around without a registration all the time. We just pay a little vig to the government every 3 weeks or so. And I think there's some jurisdictions in Canada where that's the case as well, but it's like for specific types of vehicles or something. It's just been a while since I've looked at it, but I could get you that information.
Awesome. In the chat, Sonia's asking a question that sounds like she didn't hear the earlier answer about the chickens, the recent case with the chickens, because she's talking about donkeys and horses. So it sounds very similar. We got the whole zoo going now. So, by the way, donkeys are great. When I was in Peru, I was walking around in the countryside and there was this donkey there, and I went up and he was super friendly, and yeah, they're great animals. So, just as an aside, but it sounds like Sonia's looking for a similar thing. So maybe you can just kind of mention briefly again what you talked about as far as the chickens.
Yeah, I mean, there's so many instances of local governments trying to come down on people for just living their lives and trying to grow their own food, raise their own animals. And there's a number of instances of just in my experience where equity has been able to come in and discharge those matters and get the government to just leave them alone. And we just won a case in Ontario that was about to go to trial for a woman that wanted to have chickens in her backyard. And they were harassing her for like 2 years about this. And in just 2 or 3 months worth of bringing equity to it, the whole case has been dismissed. She didn't even have to go through trial. So I'm sure if it works for chickens, it'll work for donkeys too. And of course, we've had some very brave Australian students that have paved the way in Australia and just demonstrated that everything that we're doing here is totally applicable to Australia as well. And there's just a couple of minor changes that in my research I've seen to make for Australia, but other than that, it's totally the same.
Yeah, and I wanted to just mention, like, one of the most powerful things for me, while you guys are thinking about more questions, one of the most powerful things for me was the art of inquiry, and how we use inquiry to get to the bottom of things. Julian, I'm not sure if you mentioned, but you often say, like, in equity, we have a duty to inquire. And I think that's just naturally true. I mean, if something seems off in any circumstance, isn't the appropriate thing to ask questions to get to the bottom of it? So I think
Absolutely.
I think if I can say, like when I first got into equity, like a lot of people, I was very keen on learning the acceptance process for discharge. But as I got more and more into it, what really struck me is the powerful side of learning how to ask really good questions while at the same time not creating any controversy by not making statements or claims. And that includes not disguising affidavits as inquiry notices, for example, like, not trying to have it both ways. So it gets a
Right.
little bit subtle and sophisticated, but yeah, you can learn to ask really good questions. And, it doesn't mean you're going to start answering every question with a question in your life, but you can even use inquiry with respect to private affairs. When something seems off, you can ask really good questions. So it's a very powerful, I would say, overall mindset, a way of showing up in the world.
Yeah, thank you for pointing that out, David. Yeah, that's one of really the most powerful things about the class is, I mean, we teach and it is an art form, the art of inquiry. It's it just totally flummoxes people and just leaves them in stunned silence. I mean, a lot of times where people are coming against our students in a number of different situations, like Amy said, for her kid's school trying to get her to do something. Landlords, or local governments, or clerk and recorders, or whoever is trying to push something on you or deny you something. The art of inquiry is just so adaptable. It is a little subtle and sophisticated, like you said, but we really go deep into that and equip our students to have those witty questions, just bubbling to the tops of their minds whenever they're put before an authority figure that's demanding something of them,
Knocking at your door.
or somebody just knocking at your door, you know, or a cop pulling you over. I mean, I've been let go with a warning the last 5 times I've been pulled over, and it's just because of the art of inquiry. So
Are you still
it's
speeding, Jillian?
no, I've chilled out a little bit. We moved to a more mountainous area, so I'm a little more hesitant to engage in any of that behavior now.
Why not? Why not? But actually, speaking of which, Jim in the chat did ask specifically about dealing with traffic stops. So I don't know if there's anything else you want to share since that was brought up as a question.
Yeah, absolutely. I mean, traffic cases are, everybody talks about how easy they are, supposedly. But I've seen a lot of hit or miss stuff out there. Equity is the only thing that I've seen that really can take care of it 100% of the time. With traffic, there's always the possibility that they can push hard enough to, revoke registration and licensing. It's rare that they push that far, but some jurisdictions, I mean, it's their bread and butter. Like traffic is how they make their money. So some jurisdictions occasionally push back quite hard on traffic. So you really have to be willing to take it all the way. I mean, for most traffic stuff with equity, it gets dismissed. You don't have to take it all the way, but occasionally you do, and you have to be comfortable with, just knowing that even if you have to drive around without registration and license, equity has your back. And we've had students with serious criminal cases as a result of driving without registration and ID, and get dozens of charges against them, and equity dismissed the whole thing before trial, or equity caused the case to be just disappeared from the docket. Just a number of different examples. So some things you got to be willing to take it all the way. But if you are, then equity will have your back 100% of the time.
Yeah, and I'd like to add something about the court. Now that I've had firsthand observation of people bringing equity to the court in person, meaning not even on Zoom, but like actual in the courtroom, and also listening to some recordings as well. So, and kind of analyzing how they went. I can tell you the judge is, these guys, just like Julian said, these guys are subject to natural law. They have certain agreements. They obviously are sworn to secrecy about the banking emergency, but they have to follow the rules. There are rules that they have to follow just like we do. And it's funny because when you start learning this process, you can like they're not going to even surprise you. The judge isn't even going to surprise you most of the time. It's almost predictable. Of course, you're not going to know exactly what he's going to say at any given time. But when he says something, you're not going to be surprised by it because you knew that was one of the things that he or she was going to use, right? So what Julian was saying is absolutely true. Right now, like if you go to YouTube There's a lot of these sovereign citizen channels, unfortunately. But it is an opportunity to see what we're not going to teach you how to do. Because the problem is if you do show up a certain way in court, you will definitely be labeled as a sovereign citizen. And hey, the judge may throw that term out at some point or may not. But our goal is to have you show up powerfully in court, confidently, and not be a sovereign citizen, if you want to put it that way, right? To really own the room, to be on level. We even had one judge, or she was more like not a judge per se. They called her a referee. She got she was so taken aback by how powerfully the woman showed up that she actually said, "We are not peers, ma'am." You know, she was just pushing back on the fact that the woman who was bringing equity knew that she was on the same level as this administrator. So you guys are in for a treat when you learn this stuff.
Oh, that's awesome. Yeah, equity makes you equal with a judge for sure. And that's so cool the way you put that, David, that you're just like not surprised by anything they throw at you. I mean, if you all just take a moment to comprehend just the incredible power of that, like no matter what case you're dealing with, even at the federal level where they're throwing all this crazy documents at you, you're not going to be surprised by it because it's not just a process that we teach. We teach a comprehensive understanding of everything that goes on in court and all the things that they're going to be trying to hit you with and push you off the rock on. You know, we teach you how to stay standing in absolutely every matter. So really great to highlight that. Thank you, David.
Awesome. Let's go to Ernest with your question.
Yeah, hi everybody. My question is, how many times are the courses taught? I've been told, but I just want to be for sure because I know that I won't get my money from a settlement before February. But if there is another course, I'll be willing to take it because I have the money then. And I yield the floor.
So the courses are offered about 3 times a year. And we do have a payment plan as well if that's more amenable to you. And then also, the course is starting January 21st, but we'll keep enrollments open through about halfway through the course, which will be sometime in March. So that, you may just do a late enrollment if you like, or we definitely have several options for you.
Okay, I appreciate that, Julian. But what I was thinking is I'd like to start the course from the beginning with everybody else because I don't like to get behind. I yield the floor.
I hear you. Yeah, in that case, I would just look at one of the payment plan options. You can find that at the website, standingontherock.com. We have a 3 payment plan option that pushes it out somewhat. But yeah, I feel that because people really like the cohort model and to have this community of students that they're all learning alongside. So it's understandable.
Awesome. What other questions are coming up? We are also keeping an eye on the chat. There weren't a lot of questions in from social media. We do have 40 people watching live though, which is great. So we have almost as many people on social media as we do here in the Zoom. So word's getting out. It's not a big group, and we never really expected this to be a big group. I mean, yeah, of course, we want to make this knowledge, information available to as many people as we can. But we always know at any given time it's obviously going to be a small. But I'm actually super pleased. I mean, to have 47 people in the room right now, and another 40 or so on social media, that we're getting the word out. Plus, people have been asking about the recording. So because this was live on social media on 4 different platforms, you're always going to be able to go back and watch the entire workshop. We're not going to. We have no plans to take it down, and I think those are just going to be up. So if you want to go back and rewatch anything because you missed something, then I would definitely encourage you guys to do that. And in the chat, Gerald is asking, is the digital ID truly a threat? I guess what he's asking is, what is the relationship? How do we bring equity in dealing with something like this digital ID system? What are your thoughts or opinions, Julian?
That's a great question. I think that as much as we can, now this isn't exactly pure equity, okay? But as much as we can push back on that kind of stuff, I'm all for. You you wouldn't really use equity to deal with that. We actually have some really creative solutions on how to be a part of kind of the resistance against that kind of stuff. There's some really interesting solutions that people have come up with to just kind of flummox AI systems and make it more difficult for them to do the facial scanning, the license plate scanning. When it comes to the digital ID itself, of course, there's opt-out mechanisms. Like for right now, they have the real ID, but then you don't have to get the real ID, but then they give you problems at the airport. But then there's alternatives like a passport that you can use. So there's always opt-out mechanisms that are in place at least for a time. As it goes further, then we may need to look at more like what Sonia was talking about, where we just we say we're not going to use that, and we have the tools to equip you with to be able to stand on that, and to still be able to operate in commerce, to still be able to operate a business and set things up in a way that isn't touching your name, but still allows you to make a living for your family.
Great. And someone asked what social media platforms we've been broadcasting on. So for this session, we just did 4. We did Facebook, or we are broadcasting, I should say, on Facebook, YouTube, Rumble, and LinkedIn. So those are the 4 we did this time. And in the future, we may actually expand that to other platforms that we just didn't have a chance to test out in time, or, maybe TikTok, maybe other platforms. But I figured if we got on 4 platforms, that's going to get the word out pretty good. We are not on BitChute, by the way. Somebody asked about that. Awesome. What other questions or thoughts do you guys have? I'm just looking through the chat here. Actually, here's an interesting question. Jim asked, is there any country that you know for a fact or strongly consider that equity probably wouldn't work?
I know that they do not have equity in Russia and China.
Interesting.
I've actually looked into that, but I've also looked up, like, think of another just totally random one, like, Saudi Arabia, for example. They actually have equity in Saudi Arabia. They didn't pass a constitution there until the 1990s, but it does mention equity, and there are equitable principles even within the Quran. So it's usable in Middle Eastern countries. Russia and China, they're on a whole other system. So yeah, not sure how effective it would be in those two.
Good question. Good point. Gerald also brought up a really good point in the chat. He's kind of talking how about it's some going back to what we were talking about inquiry. It's difficult for people to approach that because we've been so indoctrinated to create controversy, right? Because the system feeds off of that, like we pointed out, and it monetizes controversy in a way, even though it's supposed to eliminate it. So Gerald's pointing out that it really is very much a mindset shift to move in this position where you are empowered and asking questions instead of arguing or making statements or claims. I don't know if you want to speak to that, Julian.
Yeah, I mean, it's just such a fundamental shift in mindset. I mean, we're taught to either comply or argue. I mean, that's the line that we're fed our whole lives. And the real power comes in the soft power and authority from being able to back up what you're doing, but not making a big deal about it. Not going and arguing with everybody, just carrying that authority with you and unleashing it when attacked, but not kind of boasting and acting prideful about it. God resists the proud, but he gives power to the humble. And that's definitely borne out in our process. I mean, we shift out of that mentality of arguing. We shift out of victim mentality. We shift out of calling everybody corrupt all the time. No, they're not corrupt. It's just a broken system. I mean, they don't have to be corrupt because all the laws already favor them. Once you learn their laws, then you can force their hand to follow their laws. You just can't be stepping into those adhesion contracts. So that's really one of the most important things about what we teach.
Amazing. And some people are asking again for the contact. So can you or Mary Cho, either of you, post the link to the website again in the chat? And just so people want, it's just standingontherock.com, standingontherock.com. And let's go to Papa Love with your question.
You're muted, Papa.
First, I wanted to let everybody know it is my name in case it comes up because I get called out on it sometimes. So my questions are would with equity not really being involved in it, I'm in the process of doing status change. Would there be any effect or issue with equity and that status change? And then also, I have a friend who went to prison last month. He's doing it's not long. It's like 8 months for a DUI because he didn't have a driver's license. It hasn't had one since '92, and it became a felony because of that. So they stuck him away. Lost his $200,000 a year job, all that fun stuff. Does he have any? Can anything be done while somebody is actually locked up to potentially get them released using equity?
So this is another thing that we have at least secondhand material for. Some very influential forerunners that came before us and people we learned from, which have seen people released from prison using a very special document and procedure that it's in equity, but it's a little separate from what we teach because they're kind of attacking from a different angle. It's something that we could provide separately. And there has been, at least from the people that we learned from their testimony, there have been around a dozen people that have been released from prison using this method. It's really something that's combinable with equity. You bring equity to the whole case, and then there's this other very powerful, like 300-page document, which we have that can be applied to the case, and then a new court hearing gets called, and then the person will have to stand in court and kind of ask questions around that 300-page document. And that supposedly has seen a dozen people released from prison, but not something I have firsthand experience with. And sorry, you're gonna have to remind me what the first question was again, please.
Status change.
Okay, yeah. So equity requires no particular status. It will conflict with equity if you try to mix them. But just the fact that you've done the status change, it's not going to bother anything that we're doing. But you're just going to have to use your, whatever name that they're addressing you by is the name that you're going to have to go by in equity. We don't use status change in equity. We are the surety, and we have quite a lot of power in that role. So we have no need for status change.
Okay. Thank you. I was going to say probably the amount of time that he's got to do, it's probably such a short period of time. I mean, for us, for him, it's probably not, but probably not something that would happen that quickly is what I'm guessing. Any idea?
Well, I think it could. I mean, you say he's a month into an 8-month sentence. I think 7 months is more than enough time. But it's going to be, I mean, you're going to have to meet with him, whenever they allow you to do so, and just teach him bit by bit until he grasps the whole thing and he's ready to stand in court. And then he's going to need somebody on the outside doing the paperwork for him. And, it'd probably take close to, at least half the time. I mean, if we were moving really quick, maybe we could get it done quicker, but I mean, we could always help with private coaching matters and stuff, but it's kind of a lot. I mean, we'd be dedicating a lot of time to it because there's probably going to be a ton of paperwork that's already been done on the case. We're going to have to unmake all that. We have to bring equity to all the paperwork. If you want to move fast on it, then you're going to have to do private coaching, and so it could potentially get quite expensive to just to do it in a short period of time. But you could do it yourself after you take the class. I could give you access to the previous class recordings, and you could probably be up to par in order to do something like that. And I don't know, 2 to 4 months.
Okay. Yeah, I'm definitely taking the class, so I'll see you there. Thank you.
My pleasure. Good question, Bob.
Amazing. And I want to go back and just touch on this theme of, so in the last one of the last questions we kind of talked about, or Julian mentioned, it tends to be this polarity, like you either comply, like just give in, or you argue. So it's kind of like this polarization. So something that I've been thinking about is we're rising above the polarity here. We're rising above the either or, black versus white, left versus right, us versus them. Because again, the system loves to keep you trapped in that polarity paradigm where it's, one side versus the other. So, and there's a lot of false dichotomies. In fact, there's a whole concept called the Hegelian dialectic, where there's kind of like two false choices that you have to choose between. An even deeper one is being religious versus being atheistic. Like you either have to be in one particular belief system or you just have no beliefs at all. That's another one. So, Julian, I'm not sure if you want to touch on that at all, like how equity helps us kind of transcend the polarity and rise to a higher level from your perspective.
Equity, the shift out of the polarized thinking and yes, the Hegelian dialectic is profound. I mean, the Hegelian dialectic is built upon problem, reaction, solution. So you're presented with a problem, and it's a pre-engineered problem, and the reaction is pre-engineered, and the solution's pre-engineered. So they say, so some Muslims, quote unquote, blew up the World Trade Center. Well, we're all freaked out. We need more security. Okay, here, have the Patriot Act. I mean, it's every piece of that was engineered from the jump, to force us down a path of technocracy and surveillance state type of living. So that is the paradigm that the powers that abide have always used. Hegel, of course, was a philosopher and magician from earlier centuries. His works are very convoluted, but in large part based on secret society occult teachings, which pervert the word of God and go against everything natural and decent. And of course, this is the individual that has formed the strategy that is being used against us today. So equity transcends all of that. It gives you the tools that you need to counter the kind of occult Rosicrucian psyop, if you don't mind my saying, and gives you a way to discharge and diffuse all of that, so that you can just be left in peace and live your life.
Excellent. Excellent. And it looks like Ty has a question he wants to ask. So go ahead, Ty.
Hey, thanks, guys. This may be slightly off topic, so I apologize if it is, although it could be on topic. I was wondering if you, David, or Julian have any experience tendering negotiable instruments to the IRS as overpayments. I filled out and endorsed the 1040-ES and the 1040-V and the 1099 OID earlier this year. They actually made it to my transcripts, and I have 370,000 that are showing up as payments that have been tendered, not only by the taxpayers' figures, but also by their own computer figures. I also sent in a Form 56 and a durable power of attorney, essentially basically separating myself from the juridical person. And there's been a hold on the accounts since August, or at least a hold on release. I opened up a case with the TAS. The TAS basically didn't help me, so I ended up having to escalate to a congressional inquiry. This was around about the time of the government shutdown, and I'm currently waiting for AM Ops, if you know that department within the IRS, to issue an opinion or a response to the congressional inquiry. But I was just wondering.
I'm gonna stop you right there because we already have enough information to answer your question, if it's okay.
Got it. Okay.
Yeah.
All right.
So, Julian, I know I'm waiting to hear your answer. I'm on the edge of my seat on this one.
Yeah, that's quite a lot of commercial lines that you're opening up there. So what we've seen with the IRS is that every person has an account with at least 2 or 3 different IRS centers, and usually more if they've been doing, if they've been sending the IRS a lot of things, like it sounds like you have. All of these, everything that you send back and forth between the IRS creates a line item on an account, and it all needs to be discharged at some point. When you fill out their forms, you are giving them jurisdiction over your finances. It doesn't matter if you fill out their forms according to some specific teaching that's supposed to make you the beneficiary, or that's supposed to, give you access to something. If you fill out their forms and you sign under penalty of perjury, which many of their forms ask you to do, then you have given them jurisdiction over your finances. Now, what you said about them showing $370,000 worth of payments, well, there's multiple reasons why that is. And I've seen tons of cases like this. There are people that do processes with the IRS and get checks cut, for hundreds of thousands of dollars. And then 6 years later, they have a case in federal court over the same issue. And then there's some people that do that and they never hear back from the IRS. I mean, the IRS does not have the manpower to go after everybody that does these things, but it's a very, very risky process that you're doing. We have many students that have done, the 1099 OID process, or the W-4 sandwich, or the 1099-C process, the Form 56 with the revocation of election, various, sundry forms of status change. We've seen it all. Some of them, they just skirt by, and the IRS is like, well, we don't have the manpower for this, just forget about it. And then some of them get in quite a lot of trouble. So it's all these things are very hit or miss that you're talking about. You may be just fine, but they may just say this is too much, I don't want to deal with this. It could also lead to serious issues. And I don't want to frighten you, but we absolutely do not recommend ever filling out any IRS forms whatsoever. We pay them every single penny they ask us for. We pay over and above what they're asking for. We just don't do it with our hard-earned dollars. We do it with a very particular kind of negotiable instrument that we teach in the class. And it's not something that we're creating. We're taking their letters that they're sending us, and we simply finalize them in a particular way. So if you were to apply our methods, you would go from hit or miss to 100% success. You're not going to get checks cut to you, but you'll be left the heck alone, and you won't have to pay income taxes with dollars anymore because you'll be paying them with negotiable instruments. But it's going to require, from everything that you've told me, it's going to require unmaking those things that you've sent them, and going about it the way that we teach. And then if you do that, you'll be left alone, and you'll accomplish your goals.
Got it. All right. Thanks a lot.
Yeah, and I think, it's fair. We a lot of us, myself included, have come across a lot of these different processes, and it's very enticing. It's very seductive. Let's just put it that way, that there is a way to kind of cash into these back-end treasury accounts and so forth. And Julian, like you're saying, there are certainly people who have definitely gotten checks and, have definitely been able to see it all the way through. My personal take, this is just my opinion. I think the spirit and substance of what we do at the Freedom Studio is not really about tapping into a back-end account. It's more about staying in honor. It's more about being left alone, being private, protecting and defending the value that we are creating. And so I think that's why we don't really pursue those avenues. Because if you think about it, if you're doing filing anyway, you're going to be, in some ways, you are creating controversy, or you're opening the door to creating controversy, right? And I think that's why a lot of people, maybe, I don't even want to guess how many people, but there's probably people out there who just won't want to embrace this path because they just want to keep pursuing that, pot of gold at the end of the rainbow, I guess, or whatever they imagine there is. But I think the real pot at the end of the rainbow is already within us. That's my perspective. We already have everything we need, and reality is going to rearrange itself to give you abundance when you become a man or a woman of high moral character, of great spiritual value, embodying who you're really meant to be in this world. You're going to have everything you need in life. So you don't need to pursue a secret treasury account to have abundance. You just need to be someone of value. But that's just my
Absolutely.
opinion. I could be wrong, right?
Fair enough. And also, just a quick FYI, David, I don't know if you remember several months ago, I was talking to you about an eviction issue that I was having. But I ended up appealing that, and the landlady, they never responded at all during the appeal. So it looks like my appeal is going to be uncontested. And from what AI is telling me, I'll be able to go after the county and the landlady for wrongful eviction and judicial misconduct. So just as a FYI, I don't know if you remember me picking your brain about it months ago, but just wanted to give you a quick status update.
Okay, cool. So you weren't evicted.
No, I was, but I'm gonna sue them. I'm suing the landlady and the county for wrongful eviction and judicial bias and judicial misconduct. I'm planning it with AI at the moment, but I'm just waiting for the appeal to be issued in my favor, which it probably will because it's uncontested.
Okay. I mean, that's clearly different than equity. I mean, Julian, I don't know if you want to comment on that at all, but I mean, it's obviously a very different, and we're not even saying that equity would be used in specifically would be used in every scenario, as you
Yeah, because I'd
mentioned.
be the plaintiff in this
Yeah.
in this scenario.
Yeah.
So, but yeah, I just thought I'd let you know.
Awesome. Okay. Well, we are a little bit over the 2 hours that we allocated. And Julian, I'm not seeing any other questions, so we'll do maybe, if you're okay to go for a few more minutes, if there's any last minute questions. Otherwise, I think we can wrap up. Julian, did you want to share any closing thoughts now that we're coming to the end of the workshop?
Well, just that if you would like to put an end to the fighting and the arguing and the striving and the memorizing codes and statutes and rules and procedures, and just put an end to controversy and come away with something that is really going to stand the test of time, something that's going to protect your family, not just for your generation, but something that you can pass down to your children and your grandchildren. We make that opportunity available to you. And I don't hold anything back in the class. I mean, I teach you absolutely everything I know. And that's why people that we've taught have gone on to teach others and be successful and even make a career out of this. So it's incredibly powerful material. I know it's not the only game in town, but it is the best game in town. So if you would like to join us, we can give you absolutely all the support you need to be just wonderfully successful and just an incredible dynamo in your life and the lives of your children and your loved ones.
Thank you so much, Julian. Aaron, did you want to share something?
Yeah, I just wanted to share that I am one of Julian's students. I took his equity course in February. I've sat through 2 rounds of it now. And I really just want to impress upon the value that is given in the course that you experience with Julian and Maggie. There is no one out there that's teaching this at quite the high level that they teach. And even, after taking the course, anything that they are like discovering or learning, it is all passed down to us as they evolve this process and they become more educated in certain areas. I took both the equity trust systems class and the honor with equity class, and I took them at the same time. It was a lot of information, but I really do highly recommend that if anyone has the means to take their class, whether you're in trouble now, whether you don't even need it for anything, the amount of information that you have really equips you with a sense of certainty and a sense of like practical usage, but also it gives you a sense of knowing that you're protected, or you can protect yourself in a way, or your children or your assets, that I don't, in my experience, isn't offered anywhere else. So I just want to say from the bottom of my heart, I'm super grateful that I found Julian and Maggie through David. I'm really grateful to David as I work with his community. But I can honestly say that if you're even thinking about taking the class, you really should take the class. It's nothing else out there will teach you what Julian and Maggie can teach you.
Thank you so much, Aaron.
Awesome. And as I take us out here, I want to read a comment that I saw on the YouTube channel that I think kind of underscores the value of what we're doing here today. So somebody on the YouTube live And by the way, we still have 48 people watching live even after several hours. I think the number's even gone up. So super grateful for that. But somebody wrote, it feels like this channel is producing the most important information in these times. So many thanks to you all. And I think that's very heartwarming for me. And you know, I get comments directly to me and also indirectly through our social media all the time about the value of what we're doing. And I actually do pay attention to that. I take that very seriously, that feedback. And I really feel that way myself. I actually share the sentiment of that commenter. I feel like it's very important for us to share, again, like I said at the beginning, you know, this is just here for you if you're ready for it. It's important enough that we want to put it in front of you. It's kind of like saying, you know, we respect your free will, but just so you know, here's what's on offer. Here's what you can do. Here's something that you may not have considered that could really make a big difference in your life. And we just want you to consider it. And if, by the way, as you're considering it, what kind of world do you think you would, you know, how would your life be? And then by extension, the sphere of influence that you have, the world around you, how would it be transformed by you embodying the spirit of equity? That's essentially the real question here. So hopefully we've given you enough today. I know some of you guys have already committed to joining, and that's awesome. For the rest of you, hey, just think about it. You know, no pressure. It's just, like I said, it's just an offer. It's something for you to consider. And hopefully this was valuable enough that perhaps you found something that you didn't consider before today. So having said that, I want to again thank Julian and Maggie again for the great presentation. And I want to thank each and every one of you for participating today, whether you are on the Zoom meeting or with us on social media. So as we say goodbye, we're going to wrap up now. Just unmute yourself and maybe say goodbye or share a thank you on your way out the door. And thank you everyone for joining us today.
Appreciate it, David.
Appreciate it, Julian. Thank you.
Thank you, Julian. Thank you so much. Awesome class.
Thank you, Julian. Thank you, David. Thank you so
Thank you,
much.
David.
Appreciate you guys.
Awesome.
Thank you so much, everybody.